Wow. Marty, you draw a crowd. Good evening, everyone, and welcome, and thank you for joining us for this dedication of the 83rd volume of the NYU Annual Survey of American Law to our friend and colleague, Professor Martin Guggenheim. So this is a celebration, but it is entirely fitting that we as a community join together here to celebrate a teacher, a scholar, an advocate, a visionary, someone who has shaped the field of family law and has done so in ways that are field-defining. It's rare you can say that about somebody, but you can certainly say it about Marty. Each year, of course, the annual survey dedicates its volume to an individual who has made a sustained and consequential contribution to our profession. The survey, of course, is student-run, and the choice of honoree reflects careful judgment about whose work has mattered, not only in theory, but in practice. And if you look at the list of past honorees, it is a pretty amazing group. The decision to dedicate this volume to Marty is entirely fitting. Marty is one of the nation's foremost experts on the rights of children and families, but his influence extends far beyond any particular subfield. He has an extraordinary ability to think about problems from every angle, to begin not only with doctrine, but with the lived realities of families and children in crisis. He believed, at a time when many did not, that parents in child welfare proceedings should have meaningful legal representation. That conviction led to the creation of the groundbreaking Family Defense Clinic, which has been field-defining and field-creating. He understood that effective advocacy required more than lawyers alone, and he did something that was truly unusual at the time. He brought social workers into the clinic and into legal education. I remember, Marty may not remember this, but at one point several years ago, we went out for lunch at Pearl Oyster Bar, which is no longer there, unfortunately. And I remember asking him, so why did you bring social workers into the clinic? And he said, one of the things that they did was teach us lawyers how to listen. And I've never forgotten that insight. Through his scholarship, through his advocacy, through his teaching, Marty has reshaped how the law understands family integrity, state power, and ultimately justice. And we are fortunate tonight to hear from a range of speakers whose own work reflects the values that Marty has long championed. And to keep the program moving, what I will do is introduce all of our speakers right now. First is the Honorable Jeyanthi Rajaraman of the Superior Court of New Jersey. She has devoted her career to promoting access to justice for families and children through litigation, policy work, and now judicial service. Before taking the bench, she served as chief counsel for the Family Representation Project at Legal Services of New Jersey and argued before the Supreme Court of New Jersey. Now that's important for all of us here at NYU because that person over there was the Chief Justice of New Jersey, Arthur Vanderbilt. Across nearly 2 decades of practice, she has combined appellate advocacy, institutional leadership, and initiatives in anti-racism to narrow the justice gaps for families living in poverty. Next is the Honorable Bridget McCormack, formerly the Chief Justice of the Supreme Court of Michigan, and now President and CEO of the American Arbitration Association International Center for Dispute Resolution. Chief Justice McCormack was earlier in her career a law professor at the University of Michigan Law School. She is a proud graduate of NYU, where she was a Root Tilden Scholar, and the recipient of the Ann Petluck Poses Prize in Clinical Advocacy. After her will be William Bell, President and Chief Executive Officer of Casey Family Programs. Dr. Bell brings more than 4 decades of experience in child welfare, including leadership of New York City's Administration for Children's Services, where he oversaw a workforce of more than 7,000 and a multi-billion-dollar budget. At Casey Family Programs, he has focused national attention on reducing the number of children in foster care and strengthening families and communities so that children can remain safely at home. After that will be Richard Wexler, Executive Director of the National Coalition for Child Protection Reform. He began his career as an investigative journalist, and his reporting on child welfare laid the foundation for decades of research and advocacy. In congressional testimony, legislative advising, and sustained public engagement, he has pressed policymakers and courts alike to confront the human consequences of child welfare interventions. And last but not least, we will hear from Professor Christine Gottlieb, Associate Professor of Law and Director of the Family Defense Clinic here at NYU. Chris's work carries forward the model that Marty created through interdisciplinary representation, advocacy, and student training. She is a leading trial and appellate advocate and a national voice in re-examining the constitutional limits of state intervention in family life. So please join me now in welcoming all the speakers with a round of applause. But before we hear from our first speaker, I would like to turn the program now over to Toela Pliakos, this year's editor-in-chief of the annual survey.
Good evening, everyone. Thank you for being here tonight. My name is Toela Pliakos, and I am the editor-in-chief of the NYU Annual Survey of American Law. On behalf of Annual Survey staff, welcome to this year's dedication ceremony. We are privileged and honored to be dedicating our 83rd volume to Professor Martin Guggenheim. I'd like to start by thanking everyone who made tonight possible. I'd like to thank the Office of Student Affairs and the Dean's Office for providing our journal with support throughout the entire planning process for tonight. In particular, I'd like to thank Katie Shirley and Lily Rice for their extraordinary support. I'd like to thank our AV team, the law school photography team, and the law school facilities team. I'd also like to thank our speakers for traveling from all across the country to be here tonight. Finally, I'd like to thank our dedicatee, Professor Martin Guggenheim. It's been an absolute pleasure to get to know you over the past several months, and I cannot think of anyone more deserving of this distinction. The NYU Annual Survey of American Law was founded in 1942 with the mission of publishing practitioner-focused legal scholarship. Our journal pays special attention to emerging legal trends and significant developments in American law. We focus on practitioners in the articles and notes we publish, the events we host throughout the year, and our annual dedication. This ceremony, a time-honored tradition that has been hosted annually since the founding of the journal, honors a distinguished attorney for their significant contributions to our shared profession. Previous dedicatees include practitioners who have made profound impacts, distinguished academics, attorneys general of the United States, and Supreme Court justices. This year, in recognition of his extraordinary contributions to the development of the law and to the lives of countless individuals, families, and communities around the country, the Annual Survey of American Law is honored to dedicate its 83rd volume to Martin Guggenheim. Professor Guggenheim, a native New Yorker, received his Bachelor of Arts from the State University of New York, Buffalo. He then received his JD here at NYU Law, where he was an Arthur Garfield Hayes Civil Liberties Fellow. He began his career at the Juvenile Rights Division of the Legal Aid Society here in New York City. He then joined the NYU faculty and began teaching the Juvenile Rights Clinic. While teaching, he served as the acting director of the Juvenile Rights Project at the American Civil Liberties Union. Through his work with families and young people, Professor Guggenheim noted a significant problem that was going unaddressed. Parents frequently face neglect and abuse cases, as well as cases that could result in the termination of their parental rights without any quality legal representation to speak of. In recognition of this problem, he started the Family Defense Clinic here at NYU, the first clinic of its kind to train law students in family defense work. In doing so, he founded the Family Defense Movement, which aims to provide quality legal representation to parents facing the removal of their children from their homes, the termination of their parental rights, or both. He was the first clinician appointed to the tenure track at NYU Law, and the first clinician to be granted tenure. He also served as the director of clinical and advocacy programs here at NYU for over a decade, during which time he expanded the breadth and depth of our clinical program. Professor Guggenheim is a founding organizer of the National Alliance for Parent Representation at the American Bar Association, the first National Bar Association group for family defenders. He served as reporter for the American Law Institute's Restatement on Children in the Law. He has authored or co-authored 6 books, including his widely acclaimed and highly influential book, What's Wrong with Children's Rights, as well as scores of articles and book chapters on juvenile and family rights. Professor Guggenheim has also served as a board member or advisor to a wide variety of legal organizations and government agencies concerned with family law and civil rights. He has also argued several cases before the Supreme Court, including the 1982 case Santosky versus Kramer, in which the court held the Constitution requires the state provide clear and convincing evidence in order to be able to permanently sever the parent-child relationship, a higher evidentiary standard than the previous standard, which was a preponderance of the evidence. For these reasons and many more, Annual Survey is privileged and honored to celebrate Professor Martin Guggenheim tonight. Our next speakers will speak to Professor Guggenheim's decades-long commitment to justice for families. Then we will hear from Professor Guggenheim himself. I'd like to conclude my remarks by thanking you all again. And thank you to Professor Guggenheim for dedicating your career to bringing a spotlight to communities and families impacted by family separations caused by undue state action. You are an inspiration to lawyers like me, my colleagues at Annual Survey, and all NYU law students. I'd now like to introduce to the podium our first speaker, Judge J. Rajaraman.
Good evening. Thank you for having me. A little trip down memory lane. So in the early 2000s, New Jersey was being sued for failures of the child welfare system. Failures in how children were entering foster care, how families were being separated, and how little meaningful representation parents had when facing the power of the state. Out of that litigation came reform. One of the most significant outcomes was the formal expansion of parental representation, creating what became the Office of Parental Representation. I was hired as one of those new attorneys in the early 2000s. I had just finished my clerkship. This was my first real job as a lawyer, and I wanted it. I pursued it deliberately. I understood DIFUS, the division, the state, disproportionately impacted families of color and families living in poverty, communities I personally understood. To me, this work was bigger than a job. But I quickly realized I was unusual. Many colleagues had hoped for criminal assignments. Parent defense was often treated as a consolation prize. Judges would say, "Why would you want this?" Others would ask, "Why are you representing these people?" Then I started going to court every day. I saw the imbalance immediately. I saw due process concerns. I saw how thin some cases were. Layers of allegations connected by fragile threads. Poverty were framed as neglect. Trauma were framed as danger. I would walk out of court thinking, why are we taking these children away? Why are we separating these families? It was overwhelming, it was devastating, I felt alone. And then I found community. The creation of the American Bar Association Parent-Attorney Conference was transformative. Mimi and Prudence, who are here tonight, had a vision to build that space, created more than a conference. This became our lifeline for those of us carrying this work quietly in our courtrooms. And then Marty spoke. The first time I heard Marty Guggenheim, he said out loud thoughts I've been carrying privately. Yes, our clients are treated as disposable. Yes, the system is racist. Yes, the system is classist. It is broken, and yes, we have a right to be angry. It was the first time I felt someone articulate the grief of the work, because what we are experiencing as parents' attorneys is grief. We stand beside parents who are told, essentially, that they may permanently lose their children, and they have to respond the only way they can. I'll take that parenting class. I'll complete that substance abuse treatment. I'll attend every visit. I'll do whatever you ask. And still, there is no guarantee. Courts and agencies would tell them you have 15 months out of 22 to fix it. At the very same time in my own life, I was caring for a family member facing terminal cancer. The conversations were almost parallel to my clients. I'll do the surgery, I'll do the chemo, I'll do whatever immunotherapy, I'll take the scan every 3 months, and still there's no guarantee. This is what this work feels like. Living in a space between effort and uncertainty, between compliance and loss, between hope and a system that may still say no. We grieve. At times it felt impossible to survive this work. And then Marty gave us something radical. He told us our work matters, not in a wishy-washy way, structurally, constitutionally, that insisting on due process matters. He said objecting matters, that making that record will matter, appealing, those filing appeals matter, that naming the injustice out loud will matter. Research tells us that mattering protects people from despair, it anchors self-worth, it helps human beings endure. Hearing someone say that parent defense, like Marty did, matters, we mattered, that was oxygen. After hearing him speak, I changed. I became relentless, I objected more, I filed emergent appeals. I even got to argue before the New Jersey Supreme Court. Sometimes I didn't even know the precise rule in the moment, but I knew there was a ground. There's always a ground when the system is this imbalanced. And I would think, WWMD, what would Marty do? I could hear his voice, just do it. Nike has nothing on you. Because what he gave us was not just a critique, he gave us permission. Permission to be angry, permission to be bold, permission to fight in ways that match the stakes. This work is heavy, it's filled with grief, but you taught us how to metabolize that grief into action, into advocacy that changes laws, that protected rights, that makes a record that appellate courts cannot ignore. You taught us that before the state exercises its most extraordinary power, the power to permanently separate a family, someone must stand up and insist on fairness. And because of you, we stand taller, we fight harder, and we endure. Thank you for giving us not just hope, but hope that does something. Marty, you also have this extraordinary ability to make us laugh in the middle of grief. Just when the work feels suffocating, when the weight of removal, a termination trial, a crushing ruling is sitting on our chest, you will always say something so sharp, so precise, so perfectly observant that the entire room exhales. You have a gift of saying exactly what we're thinking, sometimes before we even found the words ourselves. You articulate what sits in our hearts, the frustration, the moral tension, the disbelief, the fierce protectiveness of our clients. And beyond the speeches, behind the academics, you show up. You answer the call, you read the draft, you listen to my half-formed theory, you help us think it through. You give us a perspective when the case feels impossible, you help us see the structure in what feels like chaos. You provide us not just the intellectual leadership, but friendship, a steady place in a field that can feel isolating and at times maddening. You help us see through the madness, and then you help us decide what to do about it. Thank you, Marty. We love you.
Thank you for including me in this celebration. I'm wearing a few different hats for these remarks: former clinician, dean, and former justice. But the title that matters most for this story is unlikely research assistant. Marty hired me as his research assistant on the advice of one of his former students, whose daughter I babysat as a 1L. I was absolutely underqualified. It was the most impactful part of my legal education. I learned not just about the law, but about the importance of centering people whose lives brought us complex constitutional questions. He taught me that poverty is not neglect, that parents struggling to get by deserve our best advocacy, not our judgment, and that when the state seeks to sever the parent-child bond, we should be sure we're getting it right. Marty has taught generations of students that protecting parental rights isn't just about parents. It's fundamentally about what's best for children. That seemed almost radical at the time, and I suspect it still does in many courtrooms today. The conventional wisdom treats parents' rights and children's welfare as opposing interests in a zero-sum game. But Marty has spent a career demonstrating that this is a false choice. Strong parental rights strengthen families, and children's well-being requires that. When I became the Associate Dean of Clinical Affairs at Michigan Law School, I hired a brilliant Michigan law graduate, Vivek Sankaran, to lead our child advocacy law clinic. Vivek would later become Marty's co-author, and Marty is one of his most important mentors. Vivek has argued before the Michigan Supreme Court more than 20 times, representing parents in child welfare cases each time. He's lost exactly once in the Michigan Supreme Court. And even that loss resulted in excellent law for families. Many of those victories came while I was serving as a justice on the court. And watching Vivek argue was watching Marty's influence rippling through Michigan law, case by case, family by family. In 2013, Vivek brought a case before our court challenging what was called the one-parent doctrine, a long-standing court-invented practice that allowed courts to remove children from both parents when only one parent had been adjudicated unfit. The other parent might be fully competent with no findings of abuse or neglect whatsoever. Under the one-parent doctrine, the state could deny that parent custody of their own children without ever proving that the parent had done anything wrong. I authored the majority opinion striking down that doctrine as unconstitutional. Due process demands individual determination. Parents have a fundamental right to direct the care, custody, and control of their children, and the state cannot infringe that right without specific findings of unfitness. Sanders was just the first of many wins by Vivek and his students in child welfare cases in Michigan. In re Ferrante, we held that parents can challenge a constitutionally flawed adjudication even after their rights have been terminated, overruling a collateral attack bar that had previously trapped parents in procedurally defective cases. In re Hicks Brown, we held that the state must provide reasonable accommodations for parents with disabilities, and that failure to adapt services constituted a failure to make reasonable efforts. In re Gach, Vivek successfully challenged a statute allowing automatic termination based only on prior terminations. The state must still prove current unfitness now, that parents deserve a hearing based on who they are today, not who they were years ago. I could go on. Each of these cases protects Michigan families. Each represents hours of work by law students who learned from Vivek. And each traces back to what Marty taught a generation of lawyers about constitutional rights, due process, and the fundamental importance of keeping families together when it's safe to do so. In re Sanders happened because Marty trained me, and he trained Vivek. And Vivek, in turn, trained his students. Together, they changed the law to better protect families throughout our state. Marty taught me that poverty is not a proxy for unfitness, that the state's burden must be high and specific when it wants to separate families, that zealous advocacy for unpopular clients is the highest calling of our profession, that clinical legal education forms lawyers who will spend their careers seeking justice for people who need it most. Marty, this thank you is long overdue. Thank you for taking a chance on me. Thank you for teaching me the most important lessons about the law. Thank you for impacting generations of children by protecting their families. Congratulations on this well-deserved honor.
It's an honor to be here on this occasion. You know, when you get old enough to have to take your glasses off to see. Celebrating the dedication of the 83rd volume of the New York University Annual Survey of American Law to someone whose work I hold in deep respect, Marty Guggenheim. My entire 40-plus year career has been dedicated to helping children and families secure and maintain well-being for themselves. At the center of that mission is my deeply held belief that every child in America, regardless of the zip code, the neighborhood, the community, or the tribal nation that they live in, deserves to be surrounded by a community of hope. And that belief is at the root of everything that we do at Casey Family Programs. The past 60 years of our work at Casey Family Programs has strengthened our belief that if America is going to make the promise of family preservation and promoting safe and stable families that is expressed in federal policy, if America is going to make that a reality for all children, then we must embrace child, family, and community well-being as a central objective of our practice and our government response systems. A response system designed to address the needs of children separate and apart from the needs of their parents and disconnected from their community will never achieve the outcomes this nation says that it wants for children we serve. We cannot secure the well-being of children without securing the well-being of their families and the well-being of the communities where they're living their lives every day. I'm here tonight to join you in honoring the life's work of Professor Emeritus Marty Guggenheim, and to thank you for recognizing Marty for being a messenger of hope. I met Marty in the mid-1990s when I was the Deputy Commissioner at the Administration for Children's Services. Marty invited me to observe the work of the NYU School of Law Family Defense Clinic. By that time, the clinic had advanced from only working with law students to creating teams of law students and social work students to work together on cases involving parents who had been accused of abusing or neglecting their children. Marty understood then that prioritizing the well-being of children also meant prioritizing the well-being of their parents. He recognized that prioritizing the well-being of children also meant ensuring that their parents had access to the resources, the services, and the supports they needed to help them and their children get through challenging times. Marty understood in the mid-1990s that one of the greatest challenges facing children and parents involved in child abuse and neglect proceedings in New York City was the unequal legal representation structure impacting parents and their children. This unequal structure resulted in parents having the least effective legal representation in comparison to those representing the children or those representing the government when they appeared before the court on charges of abuse or neglect. Marty had a clear vision of how this nation could better serve parents and families as they faced the overwhelmingly complex experience of dealing with the impact that a child welfare case and a dependency court case could have on their lives. A fierce champion of family defense, Marty was an early proponent of families having adequate and effective legal representation and support that would give them the best opportunity to succeed when they were faced with responding to these charges. And I saw that firsthand as the commissioner of ACS. The number and letter 18B is wedged in me, even though I've worked across this country, and I've never found an 18B lawyer anywhere else other than in New York City. Most of us go through our entire childhood never having any reason not to believe that our parents can and will protect us from from anything and everything. Without this innate belief, it would be almost impossible for us to ever feel truly safe. And I've met adults who went through this experience, and even in their adult lives, they still don't feel safe. Every child protective removal changes this perspective for the impacted children for the rest of their lives. The child protective removal decision also challenges and changes the parent's perspective of their ability to meet their parental responsibility of keeping their children safe. And whether they are convinced that the removal was the wrong decision, or whether they realize that in that moment, the child might have needed some help because of their behavior, it is still a moment, not a life sentence. Marty decided long ago that it was time for us as a nation to determine how much we are willing to change the experience of parents involved in the child welfare system. For Marty, the fundamental question became, what must the nation do differently in order to get a different result for the families that come before the court? And what can I do to help the nation move in that direction? Marty has been an instrument of hope, seeking to move the marginalized and often unheard voices of parents and children to the center of the legal conversation, not just the interpretation of those voices by others, but those actual voices. Every parent deserves effective representation throughout child welfare and dependency court proceedings. Children deserve it. Communities deserve it. Our nation deserves it. Thank you, Marty, for all that you've done on behalf of children and families, and for your role in helping the nation build communities of hope for all of our children, and helping so many across this nation continue to live out the best interest of children by looking at the best interest of their families. Congratulations on this well-deserved honor.
Good evening, everyone. Thank you for making the wise decision to honor Marty tonight, and thank you for honoring me by giving me the opportunity to speak at this dedication. I began my career in broadcast journalism. In that field, one pioneer from the 1940s to the 1960s remains to this day revered above all others, Edward R. Murrow. Another broadcast journalist once called him the father of us all. In family defense and family advocacy, Marty Guggenheim is our Edward R. Murrow. Marty Guggenheim is the father of us all. A few years ago, I was at a conference on child welfare messaging. We were still calling it child welfare then, organized by Joanna Woolman in Minnesota. As the event was wrapping up, we were lamenting how difficult the task is and how many challenges we still had to face. At that point, another outstanding leader of this movement, Nora McCarthy, said, "We can't end this way." I replied, "This is where being the oldest person in the room pays off." I compared where we were then, 2018, to where we were decades earlier. I'll update now some of what I said then. 30 years ago, maybe 20, you could count the number of family defense clinics on the fingers of one hand and have 4 fingers left over. Today, I said then, there are at least 5 across the country, and now there are at least 4 in New York City alone. 30 years ago, the American Bar Association had a center on children and the law. The center had a project to teach lawyers for family police agencies how to expedite the termination of children's rights to their parents, a more accurate term than termination of parental rights. But a parent representation project would have been unthinkable. Now the ABA has a thriving parent representation project, thanks in no small part, by the way, to a former director you heard from earlier. The project's work includes a task force to abolish termination of children's rights to their parents. I mentioned the creation of the interdisciplinary model. I mentioned how that model revolutionized family defense in New York and how it has started to spread across the country. I didn't mention the tiny little change in a policy manual that allows states and localities to get half the cost of family defense reimbursed by the federal government. That one hadn't happened yet. I mentioned how this new model changed messaging as these organizations began to bring cases in my court, the Court of Public Opinion. I mentioned pioneering work in that regard by Chris Gottlieb and Emma Ketteringham in the form of their op-eds. I mentioned how you could see the work of Brooklyn Defender Services behind a wonderful New York Times story about foster care as the new, quote, Jane Crow, and so on. But it was only the next day, as I was reflecting on these and other accomplishments, that I made the connection. Wait, that was Marty. And that was Marty. And that was Marty. And that was without even counting the fact that Marty was a founder and is president of NCCPR, and it was without even reaching Sandusky versus Kramer. In the years since, people have told me about other accomplishments. I've had several, wait, that was Marty too, moments. Like when I found out how the best, most specific definition of reasonable efforts anywhere in the country probably is in a state law in Montana. It happened after a family defender in that state, who also was in the legislature at the time, heard Marty speak. Or the fact that Maine now has an organization of family defense attorneys fighting back against a system that has one of the most tragic recent histories in the field. It happened after one family defender heard Marty speak. Or the sociology professor who, after speaking to Marty and seeing his work, decided to change careers and become a family defense attorney. And look at how far Marty's leadership has taken us. In her magnificent book, The Lost Children of Wilder, The Epic Struggle to Change Foster Care, Nina Bernstein tells a story about something that happened at the New York Civil Liberties Union about 50 years ago. They just started a children's rights project and hired Marcia Lowry to run it. One of Marcia's first lawsuits was Smith versus Offer, an attempt to bolster the rights of foster parents. As Bernstein writes, Danny Greenberg, then managing attorney for MFY Legal Services, put it this way in a confrontation with Ira Glasser, then executive director of the NYCLU. My God, Ira, think of the class issues in this. You think of yourself as a Brooklyn Dodger fan, a supporter of the underdog. Only a Yankee fan could bring a lawsuit like this. The Yankees would love this lawsuit. Well, Marcia won the confrontation, but lost the case. She went on to run similar programs for a time at the ACLU and to found Children's Rights, from which she has since left to found another group. But look at where we are now. The NYCLU has come around to Marty's point of view. The ACLU has come around to Marty's point of view. Children's Rights has come around to Marty's point of view. In fact, just last week, the NYCLU and the ACLU joined the NYU Family Defense Clinic in a lawsuit brought by the Family Justice Law Center, which is led by one of Marty's students, David Shallick Klein. It kind of makes you wonder what might have happened had Marty been named manager of the Mets. And David is just one of Marty's students doing this urgent work. Among many, many others, there's the brilliant practice and scholarship from Josh Gupta-Kagan at Columbia, the amazing advocacy work from Angela Burton. Perhaps you've heard a little about her lately. And some great decisions from a certain former Chief Justice of the Michigan Supreme Court. So many have worked so hard to accomplish so much. But the bottom line is this. Virtually everything good that has happened in this field, in family defense and family advocacy over the past 50 years, has some connection to Professor Martin Guggenheim. 7 years ago, Marty spoke at this gathering when the honoree was Marian Wright Edelman of the Children's Defense Fund. Marty concluded by saying, "The list of things CDF has accomplished is remarkably long. The list of things it needs to accomplish is considerably longer." Well, The list of things Marty Guggenheim has accomplished is remarkably, amazingly long. The list of things the movement he started still needs to accomplish is considerably longer. But thanks to Marty, there's a whole generation of leaders all over the country taking on that list. Some of them are teaching the generation that will come after. Thanks to Marty, there will be people taking on those tasks for as long as it takes. Thank you very much.
So incredible to be with. Marty said it's okay to cry. I want to thank Toella and Dean McKenzie and everyone who made it possible for us to be here today together to celebrate Marty's work. You're all quite lucky that I've been given strict instructions to keep this short, because I could speak for many, many hours about Marty's achievements and influence without repeating myself. But I will focus specifically on Marty's scholarship and teaching, both of which I've been lucky to have a front row seat to for over 20 years. Two aspects of Marty's scholarship are particularly striking. First, it always combines intellectual depth with an appreciation for and engagement with how law and legal systems impact flesh and blood litigants. He never forgets who and what are at stake, however much the powers that be might want to detach doctrinal analysis from the underlying social policy choices. He won't allow it. Choices that so often harm the families those powers claim to care about. Second is Marty's consistent willingness to say true things that people do not want to hear, and his ability to speak that truth to power in a way people could hear. Not always, yet, but far, far more often than anyone would have guessed. By themselves, the titles of his scholarship show the boldness of his message. His game-changing book, What's Wrong with Children's Rights, his articles, How Children's Lawyers Serve State Interests, The Right to be Represented but Not Heard, How Racial Politics Led Directly to the Enactment of the Adoption and Safe Families Act, the worst law affecting families ever enacted. That is a title. When the book getting the most attention in the field was Nobody's Children, Marty's review in the Harvard Law Review was titled Somebody's Children. And of course, he meant the somebodies who are so often denigrated by our child welfare system. These are just a fraction of his writing that influenced not only the literature, but the ways that practitioners and judges around the country understand the law of children. His scholarship galvanized the largely ignored field of family regulation. True, his writing also provided key insights from juvenile delinquency to minors' rights to abortion and more. But in child welfare and family regulation, it's not an overstatement to say Marty shook the existing ground so hard that the columns have started to teeter, and some are falling. He pointed the way forward not only for practitioners, as others have noted tonight, but also for the current generation of scholars who've been inspired by his theoretical insights and his amazing model of academic scholarship that serves the families, whose scholars, just like courts, have too often disregarded. Marty, being Marty, often focuses on the things he did not accomplish, how far there is to go. His groundbreaking paradigm for representing children, which no one has effectively rebutted, has not, he reminds us, been embraced by children's lawyers on the ground. He says he lost the mantle of children's advocate when he recognized that serving children means serving parents. And yet, Marty profoundly changed the children's bar. And as I look around this room and think of children's lawyers around the country who work every day now to keep families together, I know that Marty helped transform children's advocacy. In the same vein, when Santosky is mentioned, Marty bemoans that the clear and convincing standard is not always meaningfully implemented. But as you've heard, he did not simply establish the standard. He followed up by reconceiving parent defense and convincing the federal government that funding parent defenders serves children. And while I believe Marty underestimates the importance of the heightened standard, it is not even the most important part of the Santosky decision. He convinced the Supreme Court to say two things that are central to all advocacy in the field today. First, the court embraced the idea that, quote, the child and his parents share a vital interest in preventing erroneous termination of their natural relationship. This is the simple yet critical idea that the vast majority of time, and until shown otherwise, parents and children's legal interests are aligned, not at odds. And second, at the height of the Reagan era, Marty got the Supreme Court to recognize that family court proceedings are, again I quote, often vulnerable to judgments based on cultural or class bias. These 2 points are now made daily in family courts and more often in federal courts around the country. When I look around this room and see the advocates who cite that language to argue that parents' rights serve children's interests and to remind courts that race and class bias taint our child protective systems, I know that Marty, working together with so many of you who are here, has transformed family defense. My final point, of all the roles Marty has played and been so gifted at playing, scholar, litigator, leader of a field, I believe the most important is his role as teacher. To co-teach with Marty was to attend a master class year after year. His teaching approach was one of a kind. It never got dated because it was never of a particular moment, because it was not about teaching his substantive perspective. It was about asking key questions and creating the rooms in which students could answer those questions with the best parts of themselves. He was able to reach past expectations and through insecurities and over the mundane daily aspects of trying to succeed to which we all fall prey. He created an extraordinary number of moments in which students were able to consider truly important questions and to answer them for themselves, but not alone. Why do it that way, he would ask again and again, whether about a litigation strategy, a conversation with a client, an interaction with a colleague, or about how its student was treating themselves. Why? To what end? What end do you truly seek? What kind of lawyer do you want to be? What kind of person do you want to be? These are questions he raised repeatedly and yet never wrotely, making the space for meaningful answers. It has been a running joke that Marty's office had to be well supplied with tissues. A joke that reflected what we all understand, which is that truthfully answering the important questions in the world we live in is often coming with tears. And so I want to say out loud what I know many in this room would say and have said. Marty has been the teacher of my lifetime. I have been blessed with many incredible teachers and mentors, but none has had more influence on what I think, how I think, the work I do, and the way I live. But more remarkably, he has played this role, teacher of a lifetime, to student after student, generation after generation. Marty gave me, literally, and each of his students metaphorically, a room of our own in which to think deeply about our values and consciously devise our aspirations. There is, of course, a parallel here to what Marty has always said that our society owes families. That combination of freedom and support that empowers each of us to live fully lives of purpose and meaning, individually chosen and collectively supported. On behalf of your students, Marty, and the many, many families you've touched, thank you.
I'd now like to invite to the podium Professor Guggenheim and Dean McKenzie. Professor Guggenheim, on behalf of the NYU Annual Survey of American Law, I would like to dedicate our 83rd volume to you in honor of your contributions to American law.
Oh my goodness. This isn't fair. I have to say that I pity the people who are going to be around me for the next couple of days. I recognize some of the things that were said. There are so many people in this room who have spent their career with me. I'm so grateful that you came. I know many of you came from out of town. We've been on a journey together. It was the best journey of my lifetime. And I'm trying to think of what I can say that's truthful without denying anything you heard. So I'm going to suggest that what you heard might be partly true, maybe more than that, I don't know. I'm torn between mentioning so many of you in the room, but then I'm afraid I'm going to leave some out. But I want you to know, Mimi, I have to mention you as a special ally. Sue, we flipped the ABA. They literally wrote an article that called the Adoption and Safe Families Act the gold standard. The Civil Liberties Union was my fiercest enemy. I was fired by it because I represented a parent, and their lawyer said, this is a children's right advocacy clinic. Well, I didn't want to work there anymore. But we beat them. They're gone. And somehow, I look out in the room, David Lansner and I went to this law school together, graduated in 1971. David's litigated, he and his wife, Carolyn, more important cases in this field than anybody in this room. So many, many people, so many former students who became judges. There's still some children's lawyers that think I'm crazy, that won't agree with me. But, you know, I want to correct the record. It sounds like I had a plan. And the truth is better than these thoughts, right? So the truth is The catalyst for my career is my longest and closest friend on the NYU faculty. It's Randy Hertz. Because Randy Hertz came to this law school as a preeminent teacher, juvenile defender, and he chose, of all the clinics to work in my clinic. And I was a juvenile defender. Well, it's not fun to teach with Randy Hertz. I love him, but he's too smart. He knows everything. And every time I thought maybe he didn't get it right, he proved in front of the students that he had. I needed another job. This field is necessity, is the mother of this field. I thought, what should I teach? I was teaching lawyering. Tony Amsterdam had simulation courses. They weren't my thing. I liked real cases. Gary Bello was one of the great founders of clinical legal education. I see Danny Greenberg in the room, who was the director of that program at Harvard when Gary was there. And Gary had a vision of clinical education, which was service to the community. Amsterdam, it was teaching. Bello, it was doing. And I said, after going home to Denise and saying, I got to get another job, I asked, well, what service might I provide? Well, there were no parents' lawyers in New York City that I would have wanted anybody I cared about to be represented by, other than Lansner and Kubitschek. I'm going to teach a family defense clinic. I had to make up the name. But here's the point. I don't want to sound like Joe Biden. I never represented a parent before that. I started a clinic where I never worked in it. I didn't know how to represent a parent. Not only was that insane, but the school let me do it. And even more, there was no field. What are we even talking about? I had to discover how to represent parents. It wasn't a clinic to tell students how to do it. It was a journey together to learn how to do it. With the full support of John Sexton as dean, and it was a clinic designed to serve the community. It wasn't even a teaching clinic. It was a revolutionary idea of legal education, of which the NYU Law School is the national leader, something that Dean Norman Redlich and Bob McKay started 60 years ago. So this crazy school let me teach a clinic just for the purpose of serving the community. And of course, the first thing we learned is, well, you can't do it without social workers. They're more important than the lawyers. And then I was lucky enough to have Madeline Kurtz, who was a lawyering instructor. She said, could I join your program? And I said, you want to join my program? Come on board. So we spent the next 10 years discovering family defense. And with Chris in 2017, we wrote an article called Discovering Family Defense in the NYU Journal of Law and Social Change. What we learned was that we loved the work. Hate the field. What we learned is we could make a difference. That was astonishing to us. We actually could win. And so what we came up with was, we got to do more of this. We love it. And there are 50 family defenders staring at me right now. And what we know is we love this work. We also know we hate this field. And one of the qualities I have, again, discounting 80% of what we heard tonight, I have found a way to say to people the same thing differently. I say to us when we're at a conference, I hate this effing field. I wish it was blown up. And I say to leaders in the field, judges, and even presidents of important foundations, I say, we can do better. They're both true. I have learned to speak the truth, but to say it appropriately. To have Dr. Bell honor me is a great, great honor for me. To work with people who are doing things in the field, not Dr. Bell, that I wish would stop yesterday, can still be in a room with me and hear me tell them what we need to do differently. I also do understand us. I know what it feels like to be us. Let me end on a note that many in the room can't appreciate if they don't work in the field. We are an extraordinarily happy group in our own meetings. When we go to conferences, we get to be real, because we have to be fake. We have to say, Your Honor, too often. We are a happy people, but we have learned only when we're together. When we're with other people, even the stand-up faculty at this law school, they don't know what I do. They don't live in the communities that are ravaged by this system. I grew up in a privileged community, and my neighbors and friends know nothing about it. So when they ask me what I do for a living, I say, I'm a law professor. And then they say, well, what do you do? I say, well, I'm a clinical law professor. And they go a little further. I say, I work in family court. And I try to end it there. Because if I say more, you do that. You know, when I started the clinic, it wasn't just they didn't know what I was doing. Never represented a parent. There was no field. It was like starting a domestic violence clinic where we were representing the assaulter. The idea of representing parents was so out of kilt. So we're a weird group. We kind of keep it to ourselves. We learn you can't persuade people how bad it is unless they live in the communities that know how bad it is. Because it's not just the New York Post that distorts. It's the New York Times that distorts. So I want to end on a really personal note in my own family. It's not easy to carry this burden of hating a field and not being able to explain to people why. But I went home to Denise every night, to a partner, a firm family defender, and I never had to explain. I might say, I wish that judge got hit by a bus. And Denise's response would be, it's not good for you to feel that way, Marty. Thank you very much.
let me close briefly with, first, thanks to all of our speakers for your reflections and for illustrating how Marty's work and his life have built and have continued to shape the field. I want to thank the students and all of those here joining us for supporting such a deserving honoree and for organizing a program worthy of Marty. But last but not least, thank you, Marty. Thank you for your work. Thank you for building something that has changed lives, institutions, has changed the law. And as a colleague, thank you for being a colleague. There is really nothing like a conversation with Marty Guggenheim. I mean, I've never walked away from a conversation with Marty, even when he's telling me something I don't want to hear or asking me to do something I don't want to do. You don't walk away from the conversation without thinking and without understanding that maybe Marty is right. With that, thank you, everyone, and good evening.